Hello again, everybody. This is TJ. We're going to start with a quick video. Well, actually, this is going to go into some detail, but I want to make sure that we get through it quickly, and I want you to watch this more than once so you get all the details. There's going to be a lot of detail in this video. Over the years, we've looked at different methodologies, researched other people's techniques, tried our own, had our members give us feedback on various things, and one thing we found is that there's a key thing that people need to understand to deal with their legal cases. You think your matter is about a child support case or a DUI or a mortgage or a criminal matter or something like that. The reality is it's all commerce and it's all business. And it's all about trusts. So today we're going to talk about expressing the trust, how that's essential once you understand that, and then we're going to show you a newer document we've come across, which we think could easily replace most of the status documents and things that are out there. This will be in your member area to obtain if you're a premium member of urlaw.org, or at least come in and be a free member and try us out, but then you'll probably want to become a premium member at urlaw.org. So I'm going to go through a lot of terminology, but I want you to get the concept of why everything is a trust when it comes to courts. And then how you can use that knowledge to settle the accounts rather than fight these cases. Okay, so here we go. Why equity and expressing the trust is essential to winning. Well, we have to look at some definitions as we go. So an infant is a decedent of estate until you declare otherwise. You see, the courts presume you're coming in as an infant because you brought an attorney, you need somebody else to represent you, you're not capable of managing your own affairs, plus you're not making your claim for the proper position in the court. You're coming in the entirely wrong position. And you'll see when you read this contract, those of you who are members will get to see the whole version. We're going to just glance over it a little bit here, but you're going to see how powerful this is. And it's indisputable once we present this to them. It forms a trust which makes them liable. I love running under my own contract rather than trying to fight theirs. So, according to the IRS manual 21.7.13.3.2.2, an infant is a decedent of an estate or grantor. Oh wait, you thought that was a baby. Owner or truster of a trust, guardianship, receivership, or custodianship that has yet to receive a Social Security number. Now let me ask you folks, is it your estate that has a Social Security number or do you have one? But regardless, the infant is the estate. That's what this is more or less saying. And, you know, if you don't believe that, just read on, and the more you study, you'll see that's how things are structured. You are the infant. You're being treated as the infant, and yet you're not making your proper claim to things. And we also know that there's this valuable Social Security account accumulating there for us. It's more than you can possibly imagine. But we can't just go in there and cash it in, and that's not our goal. We're just there to use it to settle our matters as we go through life. That's a basic concept that people are missing. That's all it is. In 1933, we went bankrupt. They took away all the money. But they had to give us remedy by holding everything in reserve effectively, putting these estates together. Yet we don't know how to operate it. And once you learn how to operate, you gain a great deal of commodity and commercial power. So, once the infant receives a Social Security number, the infant begins the journey as a federal government property. You bet you didn't know that. A federal employee / taxpayer. Some call it the straw man. You may have heard that term. With the father and the mother as fiduciaries to protect the state property via the newly created Sestate Vi Trust estate for the infant. That birth certificate that was created an estate, and it's being held in trust. And it's identified by a stock certificate called the Certificate of Live Birth. Look at it. It's a stock certificate, folks. And that estate is subject to tax reporting and taxes and taxed on income based on the self-confession that it's income to the individual, and by getting you to self-report on a 1040 or 1040 form, which is a contract or affidavit, sworn to and correct and complete under the penalty of perjury. Folks, this is how you get tied into the system. But don't worry, it's just a contract. We just need to create a new trust to correct the position. Once the child attains age 18, she assumes the title of co-trustee and co-beneficiary. Now remember, a trustee in any relationship is liable. You go through life being liable, don't you? But you also forget to claim that you're a beneficiary. You need to learn how to do that, and you're about to learn that. So take good notes. So you got to claim that position as the father of the father, as described below. The father must claim the title of third-party intervener for the holder of the person occupying the office of the general executor of the infant's estate, or face consequences of abandonment in the administration of the estate. What that means is you got to step up and say, I understand what's going on here, I know how to run this, and I'm going to execute this thing myself. Okay? All you have to do is claim to be a beneficial owner to do that. That's all this really equates to. The courts and judges know this and rightfully step in as administrator under an undisclosed constructive trust for the minor child, who is basically you. Okay, you might have one who is your child, but then you're still a child even after age 18, which you're going to see here in a minute. Legally, if the father or mother are incompetent in the administration of the child's estate, or you as an adult act as a child, which we do all the time, minor, that's another term, versus being of the age of majority, and a very important term to learn. That means you've learned how to step up and take your proper position, and by not stepping up and declaring the trust. Getting an attorney and entering a plea places you as being incompetent and thus a ward of the court, not a beneficiary, and certainly someone who is acting like a minor. These terms matter, ladies and gentlemen. So you abandoned your rightful position as a primary beneficial interest title holder. See, if you don't title to a car, I got something. If I don't have that, I got nothing. And the court grabs it from you as unclaimed, just like the abandonment of property at sea. Property is abandoned at sea. After a period of time, people can come in and claim it. That's what they get us to do when we walk into court. So it's called a court, folks. That's what's actually the transaction that's going on there. And you cross the docket, you're carrying the vessel of documents with numbers on them, and you dock it in the dock. That's what's going on. So this is what is really going on in court until you claim your title and then manage it accordingly. Okay, so via the parent's state-issued marriage license, the state-issued birth certificate for a new child, they have gifted and pledged and abandoned and orphaned that minor child and left them adrift on the sea of commerce. And the child's future, labor, and his estate belongs to the United States because they're taking care of him until he steps up and takes control. And until you do this, you can't go into court and do this until you've exercised this process, okay? Otherwise, you're just going to be treated as an orphaned minor child who is a ward of the state, okay? So the child, which is you, still acting as a minor, who has not yet claimed her securities, becomes part of the collective res. The res is the property or the thing that's put into a trust to give it value. And that res is for the full faith and credit of the United States, which is a trust. And the joint and several labor, underwriter, undertaker surety for all the debts. You're liable for everything. And they treat you like that, don't they? And even the acts of the United States. Its officers, officials, offices, agents, contractors, franchises, and corporations. So, if you don't know how to control this, their position is really being a beneficial interest title holder. Your position is being a beneficial title holder, being perceived as an abandonment, somebody who abandoned a title, you lose. So by voluntarily becoming surety to be bled out, I call it, for a case, simply by giving the name or responding to any legal matter in that all capital letter name, without properly claiming and expressing the trust and relationship. So when you fail to just stop what's going on and reply properly, you get hooked up in that. We'll show you several ways to do that. We've done that through the Word Power program. That's response by creating a trust and so on. And of course the new arbitration methods that are being rolled out there, that's another way to do it. So if you look at 31 CFR 363.3, it defines what a minor is, and I bet you didn't know this. You've probably only thought about the first sentence. A minor means an individual under the age of 18. But in the legal world, the term minor is also used to refer to an individual who has attained the age of 18. Also, this could happen after you're 18, in other words, but has not yet taken control of the securities contained in his or her minor account. Now, this has to do with your Social Security minor account. It's called a minor account not because you're under 18, it's because you haven't taken control of it. Okay? And now let's talk about the elements of a trust. A trust must have a trustee. That's somebody who manages it, controls it, on the behalf of another. That's what a trust is. Anytime you give a duty over to somebody, they're your babysitter, they become a trustee. You hand them responsibility to take care of the matters of another. Well, when you have a trust, you have to have a trustee. You have to have a beneficiary and somebody who granted the trust. So that might be you, the parents, granting the child over to the babysitter. That's a trust relationship. It's going on all the time. It goes on when you order food, and it goes on when you go into court. The same thing happens. And so the res is the property. And when you give up the name, they'll make a claim to your birth estate. And that's what they're trying to seize. And they put a bond on it. Okay? All this stuff is financial terms in court. So it has res, it has a trustee, and it has a beneficiary. So let's talk about what this term says. The term minor is also used to refer to an individual who has attained the age of 18 but has not yet taken control of securities, that would be beneficial interests certificates, and contained in her minor account. That would be whatever res is in the account. And a minor account means an account that a custodian controls. That's a trustee, right? A custodian on behalf of a minor. A trust, anytime you give control over somebody on behalf of another, that's a trust relationship. So you as a minor are giving control over to somebody. This is referred to as a resulting trust. The definition of a resulting trust is a resulting trust, from the Latin resilere, meaning, I hope I pronounced that right, to jump back, is the creation of an implied trust by operation of law. In other words, just how you're acting implies the trust. That's all a trust is. People think it has to be the big official thing. So where a property is transferred to someone who pays nothing for it, and then is implied to have held the property for the benefit of another person. So when you walk into court, you give up the name without making a proper claim as to who you are as beneficiary. You're giving up all your property to them to bond, seize, and control, and they will do so and make themselves beneficiary because you failed to do so. That's all. It's the normal way it's done. But when you make your claim, they cannot disprove that you are the rightful beneficial party. That's a fact. It's impossible to change. It's just like gravity. You can't change it. So, this is going on every day in your life until you take control as one who is at the age of majority. Okay, age of majority means you're stepped up. You know what you're doing. You're putting the proper documentation and you're making the proper claim of your position when you go in there, as opposed to playing the role that they want you to play of defendant / strawman. I don't like that term strawman because it's kind of been abused, but it is the basic idea. So we can do this by expressing the trust before court, that is in writing, and then in court. We're about to show you a document where you can do that. 2, when we reply using our word power syntax response, which we've taught in our other classes, in the word power course, we create a new contract or trust, but we do it in a forensic, perfect contract method where we basically take apart their contract and then we put a dollar stamp on there, which by the way we can do on any of our documents, as consideration for the new contract. Now they're hearing our contract as opposed to our being under their contract. Okay? And then when we reply to the new common law arbitration contract method, we also form a trust. And again, that's a new technique which we have a special page for on the website for premium members. You'll have access to that at urlaw.org. You can go in there and you can learn about this common law arbitration process that we've come across, and it's been kind of spread around, but we're trying to teach it from our own point of view. I mean, people like the way I teach that information, so it's there. And but what he is to form another contract, another trust. Same with word power, syntax, and all that. And then when we express the trust before court, we're creating yet another trust. We do trusts all the time, folks, but you've got to put yourself in the proper position or you'll lose control. And the courts know this. So everything is about a trust, implied or expressed. Contracts are the supreme thing in law. So let's get into this other document next, and then we'll look at how to express the trust in writing, and then do it as a thing you do in court as well. All right, so first of all, let's say that you've presented the document you're about to see, and I'm going to let you read the document yourself, but I'm going to cover some parts of it. But before you'd go in, this is what you have to be prepared to say to support your document. Never put a document in that you cannot back up and talk about openly and clearly in court. So you've got to understand this document very well before you actually walk in and start talking about it. A while back we talked about subrogation, and I think a lot of people kind of got it a little bit backwards, so I kind of revised the script a little bit, because you have to explain what you're doing in a way that's not only logical to you, but logical to the other people you're explaining it to, right? So you can enter this document we're about to show you ahead of time, days ahead of time, a few days at least ahead of time, or as early as possible, whenever it works for you, but the earlier the better. And then you're going to go in and you're going to back it up with how you come into court. So you're coming into court, you walk across the bar, you say, in order to proceed, I require the court to recognize I am here in special appearance as the beneficial equitable title holder on matters involving the named trust in this matter. I also require this, by the named trust is the name that's on their document. It's their court case name. Okay. I also require this court to take notice of my bill of complaint in equity, and notice that I appear only in the capacity of one who is at the age of majority. We're letting them know we're not coming in as the minor entity estate. As such, I therefore direct you to fulfill your fiduciary duty to settle all accounts as trustee per the bill of complaint in equity I submitted, and recognize my right of subrogation in this matter. You recognize your right to come in and claim the position and switch roles. Now, if they try to stop you, you just say, well, I do not consent to proceed. Let me repeat myself. And you used to go right back to the beginning and say this 3 times if you have to. They will try to get you off track. They'll ignore you. They'll laugh. They'll do everything they can to not address this issue because this is a hot potato. All right? So, now if you know the document, you're going to feel more confident about what you said above here. You might revise this slightly, but I would go in with this scripted, really memorized, but have it scripted in case you get lost. Keep coming back to it. It's very important. You do not consent to proceed until they recognize your position as a special appearance as beneficial equitable title holder. Okay? So say it that way. So this would be almost a replacement for the previous subrogation video, because this goes to more direct, directly to the issue and explains what you're saying, as well as gives you the ability to express it in a trust. Remember, a trust happens by virtue of just the roles you're playing in a given situation in life. And when you go to court, there's a relationship. There's the court is the public trustee. You're a beneficiary, but you don't identify yourself as such, so you take liability instead. You don't want to do that. You don't want to be the infant minor. That's the name. That's the all caps name. It's still there, the infant minor. But in this case, you're coming in as plaintiff now. This becomes a counter complaint versus the people of whoever, or the United States, or whoever it is that was originally coming against you in a case. Okay? And so, expressing the trust. This bill of a complaint in equity presented to void proceedings and jurisdiction. Isn't that what you want them to do? There you go. Introduction and background, and with a memorandum of law. That is a separate document. It's just going to be attached to this document when you download it. Comes now John Henry Doe. That would be your natural full uppercase lowercase name, a natural living being of majority status, conducting the style condition of the principal and beneficial equitable title holder. That's more or less what you set up above, and not an infant minor, hereinafter complainant. As such, I am exercising as well as retaining and reserving all rights, natural, private, commercial, incorporeal, or otherwise, and does tender this claim and makes the claim that the tender was special deposited on the accounts receivables books of the court. You've just given us something of value, via the respondent's commercial filings and other deposits into the court's registry, who, by their own admission of the complaint showing or causing to show the existence of a qualified endorsement. So, There it is. This is how you're coming in. These are your terms and conditions under which you're going to proceed. The respondent has come to this matter related to a trust in the capacity that is unsustainable, and thus is perceived as standing in its unadulterated, non-immune capacity, and is liable for all damages incurred, assessments as well as penalties. On its face, it appears the respondents, by the way, this is the court or the United States or the attorney, whoever came against you, the attorney, intent and purpose was to take up the election to treat the within reference complaint as a draft rather than a promise to pay. When they present you an indictment or a suit or something like that, it's actually a draft. It's a bill. In fact, in federal court, it's a true bill. Okay? A complaint is a promise to pay, and a draft is an order to pay. The person holding the instrument can treat it as either. Okay, so that's what they gave you. You're about to give them one in exchange. The court converted the complaint to a draft in a form of currency conversion. There might be cause for one to raise or complain that they lack understanding, for such information is foreign to them, and it is at this time that such an individual documents lack the document's lack of knowledge for overseeing such a matter as specifically it deals in with express trusts of an estate of an infant, which invokes exclusive jurisdiction and not concurrent jurisdiction. Now you're taking over exclusive jurisdiction because it's clearly stated what you're doing. The court acts as an administrative venue as a result of the administrative acts and the Presidential Proclamation 2038, 2039, and 2040. Those are the emergency acts, okay, for which the Presidents of the United States have exercised emergency powers jurisdiction continuously from 1933 to present, according to the Senate Report on National Emergencies associated with the National Emergencies Act. To ensure this information was not ambiguous, nor it's foreign to the government, for the Senate of the United States has verified the aforementioned facts. Equity is the implied expression of a trust. Minor means an individual under the age of 18 years old. The term minor also is used to refer to an individual who has attained the age of 18 but has not yet taken control of the securities contained in his or her minor account. If you're coming in and saying that you're doing that, you're now taking control. Okay? They don't get to tap into your Social Security account through this court case. You control it. And you're no longer a minor when you do that. There it is. They imply these trusts. This has all the elements of a trust. Minor accounts means an account that a custodian controls on behalf of a minor. This is referred to as a resulting trust. The definition of a resulting trust is a resulting trust is the creation of an implied trust by operation of law. In other words, how they're acting implies the trust, where property is transferred to someone who pays nothing for it, and then it is implied to have held the property for the benefit of another person. When they create the case and they put that document in, that summons or that suit or the indictment, that's a draft value that they've deposited. And you're supposed to come in and do something with it. And we always do it wrong. So, jurisdiction and venue, the jurisdiction of proper other jurisdiction wherein the Constitution, whereby judicial power section authorizes such out of necessity. The judicial power shall be vested in one Supreme Court. And of course, that's all the courts together. And then these courts, as equity is everything and law is without equity, they must still render equity. There's plenty of evidence to support this. Therefore, this court has the power to decree inequity upon this express trust matter in camera chambers, that means privately without the public, and may enforce, that's why we call this a private action, and may enforce the Bill of Rights put forth in this bill, as expressed in the Constitution. Don't they pass bills? Don't they send you a true bill? We need to give them a bill in return to counterbalance their bill. We must remember, and shall be discussed briefly in a moment, but that an attorney who represents an individual who has not yet attained the age of majority, remember that doesn't have to be 18, that could also be an adult, is said to represent a ward of the court. An attorney holds an administrative position as an officer of the court, and as such the attorney becomes for the ward of an appointed guardian ad litem. Now, in proof that the trust exists and is for all necessities and purposes a resulting trust in that upon attaining majority, the securities, assets, properties of the infant becomes the rightful property of the beneficiary who has attained the age of majority. We're coming in and saying we are the beneficiary, or essentially the beneficial title holder, okay? You really can't say you own something, but you hold title to something, and they can't disprove it. Just by holding a birth certificate in your hand is all the proof you need. Seeing that this is the resulting trust by operational law and as a result of the principles of equity, and that it involves a minor and an infant, and or properties of an infant, the property jurisdiction is that of equity. We can only talk about estates now, if that's what's going on, and that's what is going on. Who has and maintains a right to such inherent jurisdiction. See, this went from being some sort of weird criminal thing to an equity matter, just by your declaration. Rule of law, whereby this cause being a complaint in exclusive equity jurisdiction, because it directly involves property, estate, securities of an infant minor, cites the rule of law as follows upon the Bill of Rights. So this gets into more and more. What this document does is it supports everything that you're claiming, with law, citings, everything you need, and why the court has to take jurisdiction, because it's always been dealing with wards of the court. You're just letting them know what your new relationship is. Okay, courts of equity have general and inherent jurisdiction over the property of infants. Okay, you'll find this all comes right out of court rulings and the rules. Okay, jurisdiction can only be exercised when the court has acquired jurisdiction as to the particular infant minor subject matter. Okay, well, you're going to let them know what your relationship is and how you're going to proceed. You're not just running there and saying, you don't have jurisdiction because I said so. No, it's, I am here in this capacity and I'm here to settle this matter and direct you to do so. That's all. You're not there to fight. You're not there to plead. You're not there to argue. And it's the duty of the court to safeguard the infant's property rights with great care. And to be honest with you, they don't do it. They'll act as your parent, but then they don't see to it that you're benefited. They take from you and throw you in jail, right? Or take from you. Okay, so anyway, this goes into much more detail about jurisdiction and equity. So I want you to read this over very carefully. And the court cannot act in violation of an administrative, constitutional, or statutory limits on its power. And by the way, if you have a contract outside of this, like you do the word power response contract with consideration, or you do the arbitration contract with consideration, the court doesn't even have jurisdiction over that. They have to let it go with that jurisdiction that you put it into. Okay, but the bottom line is if they're going to proceed, they have to hold your assets now in trust. And once they become trustee, and they do only by simply mere operation, and you're stating that you're not the trustee, you are the beneficiary, they have that duty. They already have responsibility over the public trust. Okay? If we didn't make this up, it's always been this way. Okay? Now, let's see. There's talks about other assets that they've maybe created, like, for example, taking fingerprints, forcing a plea, coercion, threats, anything that's gone on in the case is really forgery and really trying to put you into involuntary servitude. This document gets into that. And, of course, the Constitution prohibits that. Again, see, the reason we fall into this other stuff is because we volunteer for it and don't realize that we are. So the courts are conducting commercial business of the courts and must give or disclose to upon the party demanding the bookkeeping entries, both receivables and payables, with an affidavit and demand is hereby made for immediate production, or all evidence is hearsay is evidence into the court. The infant minor, having attained the age of majority, hereby challenges the bookkeeping and demands full accounting on other accounts receivables and accounts payables on all dividends, profits, rents, escrows, etc., resulting from the deposit of the trust estate of the ward beneficiary onto the court's accounts receivables and other intangibles. Now that, it doesn't matter whether it's a criminal case or a mortgage. This deposit happens by virtue of the documents that are put on that docket. Okay? And they're administering that estate. You're just claiming your proper position, and you're telling them you understand now how this kind of works, and no, you're not going to let them, you don't need them to administer it for you. You'll take care of that. or you require them to do it in their fiduciary capacity. And believe me, one of the biggest laws you can break in this country is antitrust. And that's what this is all about. So you're like moving for relief. You want damages in equity. See, as equity must cause equity to be done, though the heavens fall, complainant is entitled to relief in the form of damages for the following reasons. Respondent has taken the private property of the complainant under extreme duress and threat of violence against complainant's life, property, liberties, without just compensation. They want to take your house, that's pretty violent. They want to put you in jail, that's pretty violent. Without the expressed or written consent of the complainant. You see, they get you to consent, though, don't they? Through signatures, through hiring an attorney, and those sort of things. Respondent had a duty to respond to all complaints and questions because of the legal special relationship of the parties, and by not responding to the respondent is in breach of trust. See, a trustee cannot just ignore the beneficiaries. Because the infant estate and duty of care associated therewith and thereto is an express trust. Okay? So there's some verified memorandum principles of law, points of authorities on express special relationship trusts. And by the way, if they try to turn you down, you're going to demand that they show you the authorities and express law that they're applying. That's also in here. Okay. So now I'm saying it's been placed on the record that I share the same similar name as the defendant, right? Isn't it kind of similar? And their case number. However, for clarification, I am not now acting in the capacity. So this is basically what you do if you've already started a case or at the beginning of the case. Either one, you've got to make the statement. However, for clarification, I'm not now acting in the capacity as the named defendant. I am the beneficiary and equitable title holder. And they can't rebut this, by the way, folks. They can't. So none of this information is foreign to the court. This matter must proceed in equity. You're slipping the jurisdiction. Failure and refusal to proceed at equity under the exclusive jurisdiction will constitute contempt of justice. Boy, if you bring this forth and they try to move forward, do you have an appeal? So this gets into a little bit more about the elements of a trust. I can kind of let you read this, but there has to be a settlor, a grantor, a trust, or somebody who created it and who generated it, who started it, okay? And of course, they created trusts by the New Deal. And then there's millions and millions of trusts within the trusts under these different acts that you see on screen. And there are special relationship agreements that you have with that trust organization, don't you? Through the amendments, the 13th Amendment, so forth. And rights must be identified. That's the second element. Third, there must be a beneficiary identified. Well, they're the beneficiary on their papers when they give it to you, until you identify yourself really as the principal beneficiary in conflict with their position, because your name is on there and they're using your name for profit. That's why you're claiming is to be coming as a certificate holder. Just hold up the birth certificate. It's good enough. And you're claiming your property that's held in trust. They are supposed to be managing a trust for you. And they have all the assets there to settle that draft, that document, that financial document they created to come in after you. There must be shares. Of course, those are different kinds. There's different forms of those shares. A birth certificate is one. The trust must be workable. You know, they can work it, they can manage it. They must have an ending date. Can't last forever. Of course, when you die, it ends, right? So again, elements of the trust. We will go back to this again. Minor means an individual under the age of 18. The term minor is also used to refer to an individual who has attained the age of 18, but has not yet taken control of securities. See, that's an adult that doesn't know how to do this yet. But now you do. And a minor means an account that a custodian on behalf of minor, that is linked to the custodian's primary account. There's a custodian, and they're holding on behalf of a minor, and they can't abuse the trust. So they have to administer it upon your request. Now you've identified who you are. The settlor is the federal government directly and through the state and local governments. They use the lowercase names and so forth. Through the various acts of Congress and through the Age of Majorities Act. By the way, you didn't think the Age of Majority is a real term? Go look it up. Age of Majority Act. The identity of equitable beneficial title holder is a minor, both unattained and attained. Okay? So in other words, they want to call you a minor? Fine. You're still making your claim. You are at least 18. And but you want to be treated as a person of majority who can tell them what to do. But even the minor who's of age 18 can tell the trustee what to do. They can't erase the fact that you are an equitable beneficial title holder because you hold the birth certificate and you generally day-to-day manage that. Now you're telling them as trustees to do their job. So, your rights are identified by the right to attain the age of majority, to gain control of the securities held in your minor account, and be free from minor disabilities. Minors' disabilities, okay? The trust is workable. Say, once you name this, they are required to start protecting the trust. They're supposed to be doing it anyway, but now that you identify yourself, now they have to follow your orders. Because you're like the stockholder in a corporation. You ultimately are the decision maker. Okay? But they have to do it for you. So, this paragraph relates to the process by which, if you look at the Minnesota Rule 220, you'll find essentially this language. And it's in Minnesota where a lot of the birth estates are actually housed. So the Register of Titles is authorized to receive for registration of memorials upon any outstanding certificate of an official birth certificate pertaining to a registered owner named and said certificate of title showing the date of birth of said registered owner. Isn't that what your birth certificate does? Provided there is attached to it a certificate of an affidavit of an infant who states that he is familiar with the facts recited, stating that the party named and the said birth certificate is the same party as the one of the owners named in the said certificate of title, and that thereafter the registrar of titles shall treat registered owner as having obtained the age of majority as of the date of 18 years after birth shown on the said certificate. So, what it's saying is once you wake up and you know how to act accordingly, and you begin operating your life this way, and you simply make a claim. They're just simply, you can write words just like you see on screen, and as an affidavit, attach the copy of the birth certificate. You now have that claim. Now, I can do that in court. I can do it wherever I have to. But if you want to do a separate document, that's fine too. But you're identifying yourself as having done this, and this whole document does that. The aforementioned is a general court rule, meaning that it applies in principle to all birth certificates attaining related matters. This gets into a power of attorney. We'll get into that separately, but basically there's a way that you can also do a power of attorney that they default on, and therefore appointing you with some powers to direct things even further. We'll get into that later. This matter does not involve statutory or constitutional provisions respecting a minor or an infant. This matter is exclusively and specifically involves an estate trust and the property of an infant minor under equitable law. We're not dealing with the statutory law. We're dealing with equitable, simple estate law. Okay? And once you bring this into this equity, which means basically estate law, things change. It's a whole different world. Okay, and there's a little bit more about the rules. And if they want to turn you down, the complainant states that this court in good conscience and in good reason shall aid the complainant in his prayer or show cause. That's an order you can give the court via facts and conclusions of equitable law why he or she is not entitled to just compensation and or other equitable relief, that means money, to which he is entitled as an equitable beneficial title holder. See, that's how you state it to him. Show facts and conclusions of law. It's just a simple motion. Okay? And we'll show you in a separate document, how you might bring this all into a separate court. But really, this by itself should put a stop to what's going on. Add to it the common law arbitration or the syntaxing evidence that you can put together, and this becomes even more powerful. But it's by itself is a standalone process. Okay? If you understand the language of this, understand these words, equitable relief, infant, minor, age of majority, this will make a lot of sense to you. And you can find on the internet the judicial interpretation of jurisdiction under Pomeroy, equity jurisprudence, if you want to learn more about that. We're not covering that today. Court of equity grants the relief of compensatory damages in connection with some other specific relief and other very particular circumstances. It decrees the payments of damages alone. Several kinds of equitable suits are wholly pecuniary in their relief, and those for contribution and exoneration. Again, see judicial interpretation of jurisdiction. So this gets into the maxims of equity a little bit. What's property? What's ownership? Again, I'll let you read through that. But bottom line is you just simply sign this. You file it with the clerk, directed to the judge directly, privately. That's really the best way to put this kind of thing in. And this is instead of getting into the case and arguing, you're really kind of creating a counter complaint, and you're forcing the court to go into equity. Okay? And you're not signing by your general name that you always use. You're signing as complainant and equitable beneficial title holder. Now, folks, you think, well, why can I do this? Well, if you read the laws that we've given you, some of the examples in this, you'll see that it's more than doable. And there's a memorandum of law which you want to attach to this when you file it. I'm not going to read that tonight, but it is included as an exhibit here. Okay, so you can go get the document off the premium member area. I think right now it's in the startup folder. It may go into a different folder having to do with bonds and trusts later. Just go look for the one that's called Express the Trust, and you'll get this document. But this goes into the memorandum of law supporting trust law and why they have to follow it. Okay, the reason they have to follow it is because it's inherent in everything, folks. It isn't an option. They set up a trust. You set up a trust when you order lunch. When you buy gas, you set up a trust. And when you go to court, you create a trust relationship there as well. And they are trying to take from that trust. And you can stop them by identifying yourself properly and moving accordingly. You just don't say, I want my right of subrogation, and cross my fingers. That's never been what that meant. So now you have a way to explain it, understand it, have some background, have a working understanding of it. Just know the basics, that there's a trust. There has to be a trustee and a grantor and a settlor, a beneficiary, these basic titles. Once you understand that you are that beneficiary and always have been, and a beneficial title holder to this trust, to the birth estate trust, to the Social Security trust, and to whatever court matter they're using your name for, you're a beneficiary of it. Well, they can't ignore you then. They won't want to go there. But that's how you basically want to handle this, okay? It'll be sticky, but you have to stick to it, okay? There's no silver bullets, but it is powerful. And I think even in conjunction with, like I said, possibly doing a syntax reply into the case, the way we normally do it, that creates a trust. You're also a beneficiary of that trust. If you do a common law arbitration, well, again, now they are forced to recognize the articles and the laws of Congress, which they were formed under, that arbitration is supreme if there's a contract that requires arbitration. And we give them a contract that requires arbitration, and that contract forms a trust, which we are clearly the beneficiary of and the grantor of. And it puts them in the position, again, of trustee. So all these things we're doing puts them back in that position of trustee as the liable party and taking it off us. Do this as a business transaction, folks. It's not about fighting in court. So once you understand these basics, you'll get this. Don't get overwhelmed. Read this a few times. It makes perfect sense. Do not ask me a bunch of questions about this, that, and the other thing in it. I'm not the author of it necessarily. I'm just a teacher of it. Okay? But I get it. I totally get it. And it's really not that complicated when you really sit down and think about it. We'll get more into the other issues of arbitration and those other strategies and enforcement later. But if you got to go into court, get this script in your head, and of course delete all this. You want to put a stamp here, don't leave the word stamp on here. Duh. Their case number, don't leave that on there. These are just reference notes for you. But and delete this whole script. Maybe put it somewhere else where you can memorize it. But put their cause number, which is essentially their case number. Okay. And file this thing into the case and send a copy over to the prosecutor or the attorney that's suing you if it's a suit, or if it's a bank in foreclosure, send it to them. Send it to their attorney that's been sending you stuff. Okay. All right. Get this in the case. That's the key. Stand on it. In your next appearance, you say, "Well, I'm not here to do all that other gobbledygook, but I'm here before I can proceed." And require the court to recognize I'm here by special appearance as the beneficial equitable title holder on matters involving the named trust. And that would be your name, right? And the case. I also require this court to take notice of my bill and complaint of equity, this document here, and you hold it a copy up if you have to. They'll try to ignore it. Always have an extra copy. And notice that I appear only in the capacity of one who is at the age of majority. As such, I therefore direct you to fulfill your fiduciary duty to settle all counts as trustee per the bill of complaint and equity, per this directive. You've already given them. I submitted and recognize my right of subrogation in this matter. That's just simply saying I have a right to come in here and take my position. Okay? I don't think it's that hard. Fill it out, put it in, memorize as much of it as you can, know it well, understand the argument. They're going to get you off. They're going to try to confuse you. Say, I do not consent to proceed until we get back to this main issue first. That's my capacity that I'm here in, sir. And it's not being disrespectful, and with all due respect, you don't argue with them. You're there to settle it. So do it, folks. I think you can. That's it for this video. We'll catch you next time.